Judgments and proceedings that were made by the suspended anti-corruption court since its inception hang in balance after lawyers asked the Constitutional Court to nullify all proceedings made by this court. Mwema argues that whereas the Constitution demands that an accused person be given a fair, speedy and public trial before an impartial and competent court, the anti-corruption court wasn't competent.
If a magistrate commits judicial misconduct in this court as it is, there will be difficulty in disciplining that magistrate. Do you appoint it? Do you know how do you proceed? Because this is a high court.
The hearing of this substantive petition comes 2 months after the Constitutional Court issued an interim injunction staying all the criminal proceedings that were going on in the High Court and Corruption Division and those arising from the magistrates pending the determination of this main petition. This matter arose on January 7th this year when a concerned lawyer, Davis Wesley Tusingwire, dragged the Attorney General to the Constitutional Court over the same. Should the Constitutional Court agree with the submissions of these lawyers, it will mean that all convicts now on remand will have to be released from prison.
The division of the High Court, called the Anti-Corruption Division, is not a High Court. And it cannot function as a High Court because it is not composed of the mandatory constitutional composition.
It will further imply that the current 251 pending cases at the Anti-Corruption Court will be dismissed. But on the contrary, George Kaema, who represents the Attorney General, argued that there is no illegality for the magistrates to perform judicial duties at the Anti-Graft Court. The judges will give their ruling on notice.